Honor, may it please the court, my name is Joseph Morais, appearing for the Crown Prosecution Service. With reference to Section 590AA 2E of the Queensland Criminal Code, the Crown seeks a ruling on the competence and compellability of a total of 5 witnesses for the charge of grievous bodily harm against Gareth and Lara. Apart from the co-accused Gareth and Lara, the next witness would be the aggrieved party Maud, who's a 64-year-old lady suffering with dementia. The other 2 witnesses are the co-accused children, Sally and Trent, who's 18 and 10 years of age, respectively. We also seek a further ruling on the admissibility of a key piece of evidence that was uncovered by the police on the day of the attack. Firstly, we look at Gareth and Lara, who are husband and wife. Section 9 of the Queensland Evidence Act provides that any competent person is compellable to give evidence. Moreover, this is reiterated by the decision of Hoskins versus Metropolitan Police Commission that every competent person is compellable. In the common law case of the Crown and Payne, provides that if two people are indicted and tried together, one is not competent witness against the other. However, under Section 8, subsection 1 of the Queensland Evidence Act, Gareth is a competent witness for the defence. However, he is still ineligible to appear for the Crown. To allow Gareth to be competent and compellable for the Crown as a witness, we seek that Gareth and Lara, who are the co-accused, be tried separately. Being married to Lara does not prevent Gareth from giving evidence against her under Section 8, subsection 2 and Section 8, subsection 3 of the Queensland Evidence Act. And also, this is reiterated by the case of Callanan and Bush. Section 1C of the Sentences and Penalties Act also stipulates that this grievous bodily harm is a prescribed crime, which is of very serious ramifications, and therefore we also ask Your Honour to consider the case of Crown and Apostolides and having these 2 co-accused as witnesses tried separately. Next, we look at Trent, the 10-year-old son. Prima facie, according to Section 9 of the Evidence Act, a 10-year-old is also competent and able to give witness. Trent is a child and therefore, as defined in Section 21, capital AD of the Evidence Act and subsection 9(2) of the Evidence Act, any person that is competent to give evidence and also able to give an intelligible account of the event is deemed a witness. This therefore applies to Trent, who is, if deemed competent, will also be compellable as per Hoskins and Metropolitan Police. He will also be considered an affected child under the Queensland Evidence Act, which is basically due to the fact that he saw this horrific crime committed against his grandmother, and we will need to use the procedure under Section 21AC that although they are not defendants, they are witnesses to relevant procedure of violence, and there is a prescribed relationship between Trent that the co-accused are the parents of this child. He was under the kitchen bench when this attack occurred, so therefore it is questionable about his ability to give evidence. Therefore, we can call in an expert witness under the provisions of Section 9C of the Evidence Act to help determine whether Trent can or cannot give an intelligible account of the events due to the young age as well as the trauma suffered subsequent to witnessing this horrible attack. Next, the daughter, Sally, the daughter of the co-accused Sally, who's 18 years of age. She can give evidence under Section 9 of the Evidence Act as a competent and compellable witness who was present at the time of this attack inside the house. This is also supported by the common law case of Hoskins and Metropolitan Police, Your Honour. Next, we look at Maud, who is the lady who was attacked, 64 years of age, suffering with early signs of dementia. Now, after the attack, permanently deaf in 1 year, and she will require an accredited interpreter to give oral evidence under Section 131A, and as these must be exact words. So therefore, the trauma might have caused ability for her to give oral evidence. Therefore, a written affidavit might be obtained to give evidence. We can also call in expert witness under Section 9, capital B and C of the Evidence Act, and also use the safeguards outlined under Section 93A of the Evidence Act to get testimony from this particular witness. Section 9B provides that any person giving evidence must understand and must do so over and above the ordinary duty to tell the truth. This was considered in the case of Crown and BBR. The Crown will respectfully let Your Honour decide whether or not Maud can understand the gravity of giving evidence in this serious matter, and that testifying has an obligation to tell the truth. Uh, as this is because she is a patient suffering with dementia, and now the trauma suffered as a result of this horrific attack. If deemed competent, Your Honor, the Crown respectfully asks that Trent and Sally would be also allowed to give evidence, as they are affected children under the provisions of Section 21, capital A, capital K. Thanks for considering these witnesses, Your Honor. Next, we look at the CCTV footage, which is a crucial piece of evidence that was uncovered by Constable Jones after this horrific attack on this old woman. In the public interest, the Crown submits the following. In accordance with the 5 key principles in the case of Bunning and Cross, there was no deliberate breach due to the perishable nature of the evidence that was being on a mobile phone, which actually belonged to one of the co-accused and defendants. Constable Jones, who confiscated the phone as a response to pressing circumstances, the circumstance being an attack on an elderly woman of 63 years of age with dementia. Given that the CCTV evidence was actually stored on the phone, it is likely to have been deleted and tampered if it was left behind by the police after this attack. Section 160 of the Police Powers and Responsibilities Act provides search without a warrant should a police officer have reasonable belief that the evidence might be destroyed or tampered with it. The gravity of the charges here are grave, Your Honor, and the complainant, Maud, has suffered immensely as a result of this GBH caused by the co-accused. The complainant also already has reduced mobility after this vicious attack. Constable Jones did breach the powers of the PPRA, however, did not do it with the direct conflict of the purpose of the Act. His actions are consistent with safeguarding and protecting citizens of the state. In contrast, in the case of Crown and Day and the evidence of submission was dismissed as it was not an emergency. However, this was an emergency, and we ask Your Honour's Court to allow this piece of CCTV evidence to be tendered as evidence in the case against the co-accused. We have no further submissions, Your Honour. Thank you.